Hi everyone, this is Arkady from New York City. Happy New Year. Welcome to 2024. This is the first video I'm shooting this year, and today is January 10th, 2024. And I wanted to do a last week tonight where we answer your questions and we talk about your comments. It's all about you, the viewer, on this episode. So let's get into it. I'm going to be reading the questions from the chat. This is the most recent questions we've been getting from the chat. I'm trying to go through them, get to the interesting questions where the answers could be helpful to a lot of people. So court is in session. Okay, let's get into it. Let's see, what do we have here? Here's a question from just 4 hours ago, or rather a comment, and it's in response to the video, how car accident settlements work. And this particular individual, he said he just got T-boned on Monday, and he's hoping this goes quickly. Luckily, it was minimal bodily injury, but a severe concussion and body aches. Yeah, I'm sorry to hear that. I'm wishing you a speedy recovery. You know, health is always number one. You got to take care of yourself, get checked out, go to an urgent care, an emergency room, you know, whatever's easier, whatever's more convenient for you. See a doctor, whether it's your primary care physician or if you want to see a physical therapist or one of these medical centers that treat people after a car crash. Sometimes they have a lot of different providers all under one roof. They'll have a chiropractor, an orthopedic, a psychologist, acupuncturist, you know, whatever you need, massage therapy, and then, you know, get better. That's the most important thing. But if you need a consultation, if you need anything from us, just text me, 347-566-9595. I'm here for you. I did a lot of consults this week. You know, I was away for a bit. I was out in California, actually, San Diego area. And then I went up to this area called La Jolla, very pretty, where you have like these waves crashing onto the beach, and you have the seals right there. So I was there. Then I went to Palm Springs in California, spent a little time there, played a little tennis, just like visited the area. That's where the New Year happened. And then I went up to Utah and did a little skiing. I was in Salt Lake City area, Park City, very beautiful town, did some skiing, and mostly in Park City, also in the canyons, which is part of Park City. So had a good time. I did a little work as well, spent time with the family. I got a little bit rejuvenated, you know, reinvigorated, got the batteries charged. So now I'm back in the office, prepping for some trials. We already have some trials scheduled, you know, possible trial in March, definite trial in April, and, you know, talking to a lot of new clients, talking to a lot of viewers like you, people that texted me. I didn't always have the chance to get back to them while I was away. So I made this week, I made it a priority. Every day I'm speaking to at least one or two people, you know, making it a priority to call people back, give them consultations, give them insight. And it's good. It seems like it's working, you know, for them and for me. Like, for example, just today I spoke to a nice gentleman and he was involved in a car crash. Sounds like what it was, a traumatic brain injury. It wasn't in New York. So I actually did a lot of research and I found like the best lawyer in that particular state. And he says he spoke to the lawyer already and most likely it's going to work out. So I'm glad that these I could put people together like that. I'm glad that it works out because he actually never had a lawyer. Even though the crash happened a few months ago, he never got a lawyer because all the lawyers he spoke to that he was able to find on his own just, you know, they didn't know what they were talking about. They didn't know anything about traumatic brain injury. They had no experience. So I actually went to the American Association of Justice. They have a specific traumatic brain injury group that's limited to attorneys. Only attorneys could join this group, but it's like some of the creme de la creme best attorneys in the entire nation. And I spoke to one of them and he actually happened to be in the same city where this particular individual got hurt. So it was a perfect way to work everything out. And I'm happy that I could help this man because this poor guy, you know, he sounds like such a nice guy, young guy. He had young kids, wife, and he's a church-going guy. He couldn't go to church after this crash. He's really having symptoms of traumatic brain injury, but because he's all by himself. You know, hospitals are just going to make sure you're not going to die and send you home, treated and released. They're not going to give you the care that you need. And being on your own, it's hard to find the neurologist who's going to quarterback that care, who's going to send you to the right, doctors, to the right neuropsychologists, to the right neuroradiology and testing, all the diagnostic testing like the susceptibility weighted imaging or diffuse tensor imaging or all the 3T, in-depth MRIs. Not everyone's going to do that. You have to, first of all, it's very expensive. Insurance doesn't always cover it, and you have to have the right neurologist who's going to be able to work all that up. So I was happy I could make that happen, and I'm speaking to a few other people as well. So if you have any questions, just text me. I'm here for you. Our goal is helping serious injury victims and families. That's what we're all about. So we're just going to continue that in 2024, make it a strong year, and help as many people as we can, because I'm really grateful for the opportunity to help people. And I feel like when I help people, then it kind of empowers me and gets me going and gives me that sense of happiness and hope, and makes me work that much harder. Okay, let's see what other questions we have. Here's a comment again from a Mr. R or Mrs. R Calabase. And he or she says, in response to the video, empowering injury victims. This individual says, your videos are so comforting when I'm wondering and stressed about my case. There have been many times you have answered a question and put my mind at ease. Thank you. Oh, thank you. Yeah, thank you for watching. Thank you for, commenting. Yeah, please interact with us. Give us your questions. Give us your comments. Tell us how you really feel, good or bad. Interact with us. That's what it's all about. And here's another user, and this person says, it doesn't matter unless the plaintiff dies, you're only getting $250,000 tops. And this individual is responding to the video, how insurance companies control risk. It's actually a short. Yeah, I think that's actually incorrect. I don't know what they mean by you always get 250,000. Obviously, that's not true. If you watched our channel, just our channel or other channels, you see in the media there are a lot of people that get more than 250,000. So I don't know what they're talking about. But yeah, I mean, the important thing is that it depends on the amount of insurance that's available. So if you're suing, for example, in New York City, if you're suing the city of New York, there have been many cases where the verdicts have been 10 million, 5 million. We just had a case where we settled the case for 3.5 million. So 250 is never the cap unless that's all the insurance that is available, which, in a car crash case, it could be a 250 policy, no excess, no umbrella. It's possible, but it's not always. Nothing is always. You just have to take it on a case-by-case basis and do an analysis of that specific case. Okay. Let's see what other questions we have here. We had some comments to this video about the defense medical experts, or the DMEs, where they, what happens is the attorneys, the defense attorneys, are just exchanging the 3101D cover letter, which gives you the name of the expert, the doctor, what the doctor is going to testify about, and they're saying that the doctor is going to testify that there's degeneration, that the injuries are not caused by the incident, right? Whether it's the fall or the crash, not caused by the incident, that it was from something else, like living your life, the painless, normal aging process, right? But these lawyers in this listserv, what they really found out was that these doctors never even saw the patient, or if it's a radiologist, he or she's got to read the films, right? They never saw the films yet. So these defense lawyers are serving these exchanges knowing that the people they picked are going to side with them, so it's complete opposite of independent medical exam, because an independent medical exam is like, I'm neutral, I'm independent, I have no skin in the game, bring me your patients, let me examine them, and I'll tell you what I honestly feel. bring me your diagnostic imaging, like the MRIs, the x-rays. I'll tell you, hey, I see a fracture there. I don't see a fracture there. I see a herniation here. I don't see a herniation here. This is a traumatic herniation caused by the crash. This is a degenerative herniation. And what's the difference, if I'm really independent? But what's happening here is these lawyers know full well, because these are the people they picked and paid, right? They pay them and they pick them and they use them over and over again, time and time again. They use them in cases after cases after case, right? They always use these experts. So they actually serve the expert disclosure and say, this is the expert, but the expert doesn't even see the film, doesn't even see the patient. And then later, they're going to invariably, as a matter of course, they will say that this patient is either a malingerer, or that, it's not related to this car crash, that it's all from living their life, it's all degenerative. So it's really silly. I mean, you can't really do that. Imagine if a plaintiff would do that, right? Imagine if a plaintiff who's injured in a car crash would serve a doctor and say, this doctor's going to come to court and testify that my spinal fusion is life-changing, and then this doctor never even saw me. How would that play, right? You would get probably sanctioned and precluded and get your case dismissed. But this was a tactic that these defense lawyers were doing, and I'm not really sure why, because if it's a good plaintiff's lawyer, once they see that, and this particular lawyer in New York, he did see that, and he actually ended up cross-examining that particular doctor on that fact, and the jury got wind of it. They saw it right away, and then they ended up allowing for millions and millions of dollars, much more than the insurance company would have paid otherwise. So they actually hurt the insurance company, it hurt the defendants. But I thought it was an interesting story, so I did a video about it, and we got a lot of comments about it. Like James Jordan said, they should not be able to play these games. How can the defendants hire an expert who doesn't read the x-rays from an MRI but gives us conclusions? We hold these judges to the rules of candor, report their bias to the judicial commission or whatever state you live in these United States, and you still have to fight with them. Yeah, I mean, it's just crazy. It's really something that shouldn't be happening. And I guess it's the law in New York where they don't have to give you the medical report. They just have to give you the basis of what the expert will testify about. But I think the law or the courts are deferring in good faith to the attorneys, that the attorneys will hire an expert that reviewed the evidence, an expert that saw the patient, an expert that reviewed all the medical records and the diagnostic films like the x-rays, MRIs, and they just kind of assumed, well, you're not going to just pick a name, John Smith, who's never seen your client, has never done anything, but he's going to. But I guess, maybe they were pressed for time, or they just did an and they forgot to get an expert. And then I'm not sure exactly what happened or why they did it, but it happened in that case. So it's interesting. It's interesting. Let's see, what other questions do we have here? Let me try to get you some good questions. Oh, here's a comment, and this is how to negotiate settlements in personal injury cases. Another short that we did, and this particular user says he never asked anyone for more than $150,000, and I think she's talking about me, and I don't know who this person is or why she would think that, but of course we asked, for more than $150,000. $150,000 is not really that much. I mean, if it's a soft tissue case, like soft tissue meaning there's just 3 months of medical care and no surgery, no injections, nothing like that, yeah, 150 might be a good settlement, or we might ask for that and settle for even less because it's completely soft tissue. It's just massage, chiropractic, physical therapy. But if there's like an injection, we've gotten $500,000. If there's a fusion, we've gotten into the millions. Like I said, we just had a settlement for $3.5 million on a fusion aggravation, and we had another one for $1.8 million, another one for $2.8 million, another one for $1.4 million, and another one for $1.5 million. So we've got many, many cases for over $1 million. And then the partnerships that we have with different lawyers all over the country, those lawyers have gotten excellent results. And you've seen some of the videos I did just before the new year. There was a verdict for, I believe, over $100 million against Amazon, and there was a $40 million verdict and a $16 million verdict. So I don't know where these people are getting these numbers or what they're talking about, but I guess People just like to troll the internet and say things. Maybe they try to get you upset, or I don't know what it is, but whatever. I mean, and the other thing about it is that, this particular individual keeps talking about what, you're going to ask for. He never asked for more than 150. You should ask for this amount. But, that's the other distinction that's very important to keep in mind, that as a good lawyer never really asks for anything. A good lawyer tells the jury what true value is, right? Because jurors are just your neighbors, your friends, common everyday people that get a summons and that get called in for jury duty. You don't ask them, say, please, I'm begging you, can you give me $1 million? No, what you do is, as an attorney, you educate them and you explain to them the life-changing forever injury that your client has. You show them all the medical records, you show them the diagnosis, the prognosis, and the history. You explain the MRIs, you explain whether it's a fusion, the surgery, you call the doctors, you talk about the traumatic brain injury, whatever the injury is, the orthopedic injury, you show them demonstratives, the slides, the videos, the color imaging, and then you also use economists, vocational rehabilitation experts to show the economic damages. But the most important part are the non-economic damages, the pain and suffering. But then at the end of the case, or even sometimes you like to do it both at the beginning and at the end to just be honest and say, look, this is what it's going to be. You don't just, ask for this number, like begging them to give you money. No, what you do is you tell them full justice in this case is $1 million, or full justice in this case is $10 million, whatever it is. And you explain why, and then you do it in a relaxed, calm, but persuasive and powerful, passionate manner. And then you get that money. So it's not about asking, it's about telling. And that's very, very important. Okay, let's see what other questions we have. Skip over some of them. Some of them I've answered already in a written form, or I've already talked to these people on my text that they've texted me already to the 347-566-9595. So I don't want to go through it again here. So I'm going to pick the good questions, the ones that can help a lot of people and that are interesting. Well, here's a comment from Powell4661. He says, even on the slopes, he works hard to educate us. And he's referring to my video, What is the Case Worth? And that was actually a video I did also while skiing. And what I talked about there was the fact that the jurors in a trial really care about the bad conduct of the defendant. So even though the law, the judge tells them, you're not supposed to think about what happened in liability, right? Sometimes you have two separate trials. It's known as bifurcation. So liability answers the question, who's at fault? And then you can answer that question, the defendant was at fault. Now that trial is over. Those jurors sometimes can go home, and now you get a new jury, and now the question is only damages, meaning is the fair amount of money to compensate the plaintiff for all the harms and losses, including the pain and suffering and the economic damages like lost wages, everything, right? What's the fair number? And you're only supposed to focus on damages. So you're supposed to focus on damages to the plaintiff. But what happens, because it's human nature, right? If they did something really, really bad, if they were negligent in a sense that they were careless, they were reckless, they were wanton, they were malicious, they did things that they knew were going to hurt people, but they did it anyway, then the jurors want to give more money. Sometimes it rises to the level of punitive damages or exemplary damages, where you want to punish, and you're allowed to legally punish the defendant for their conduct and actually look into their financials, how much money they make, and then say allow for a day's worth of income, right? Like if they make $1 million a day, I'm going to punish them by making them pay another $1 million because of their conduct. Because they knew, for example, that these truck drivers were tired, they shouldn't be on the road, it was a violation of federal law, but they said, we don't care, we want that load delivered because we need to make money. Go out there anyway, even though these truck drivers are driving, say, 15 hours in a row, they're falling asleep and they're likely to kill somebody, right? That would be an example of punitive damages, something like that. So, but this was not a punitive case. The case I'm referring to in this video was a case where somebody actually was walking and they got cut on their leg by a broken pipe, but it turned out that the particular development had this machine, you know, and they rented the machine. I forgot the type of machine it was, but it was a machine to fix the broken pipe. I think it was like an excavator machine. They rented it. It was like $300 a week, I think, to keep the machine there. And the owner of the development, he actually said, you know what? I don't want to pay the $300. He was like, F these people. He didn't like the people, and I don't want to get into it, but he didn't like the people, the ethnicity of the people that were living at this particular complex. He was this out-of-state developer, a little bit racist, and he just didn't like these people that were staying at this development. So he said, F these people. I'm not paying $300 a week. And then he didn't pay. So the company came and they repossessed the machine, took the machine off the premises, and the broken pipe remained. And then somebody cut their leg on the broken pipe. And that's what the jury told me after the verdict, that what they really cared about was the way in which the negligence happened, right? Not just that somebody, because, you know, somebody could be negligent. They could, because what is negligence, right? Negligence is not using reasonable care. So you could just be negligent. You could try to do your best. You could be a careful person, but you could make a mistake, right? I could be driving my car and I could be going to, I don't know, church, or going to help somebody, going to volunteer for the homeless. But, you know, I get a ding on my cell phone. I look down for half a second and, oh, boom, somebody stopped short. I didn't see them. I didn't mean to do it. I didn't want to do it. I was negligent. I didn't use enough reasonable care in that split second, in that half a second, that quarter of a second. Yes, I'm at fault. But this situation is a little bit different, right? Because this guy, he knew he had the broken pipe. His manager was complaining to him that he has these broken pipes, and they're in the walkway where people are walking. And, you know, the manager even hired the company. They gave you the equipment. It's being fixed, but it's like $300 a week. The guy's a very rich, like multi-millionaire. And he just says, you know what? F these people. I don't care. I'm not going to fix it, you know. And they repossessed the equipment. It never got fixed. It was broken for years and years. And the manager, the former employee, was actually going to come to court and testify. So then what happened is the defendants, I think maybe they got wind of this, that we knew all this and that we were going to call this employee and get all this evidence in. So they actually conceded liability. They said, you know what, we are at fault. So now the only issue is damages. They thought that was going to help them, but we still got it out in our case in chief about all this in a quick way. We couldn't really get it out in a detailed way as we would have if they did not concede liability, meaning they admitted fault, right? So once you admit fault, you're not supposed to talk about fault anymore. But I kind of still got it in through the back door because that's what good lawyers do, you know, get in. But then it was very interesting to me that the jurors all said that too, because what I really like to learn as a lawyer is the way jurors think, right? Because I know how lawyers think. I'm a lawyer. I know how I can always talk to lawyers, but jurors think differently than lawyers. And these jurors, they said it in that video, that the way what they really care about is they care about the bad conduct of the defendants. That's very important. Okay, let's see what other questions we have. And I'm going to do a few lives too. I want to do a few lives. So when we do the lives, then, you know, we'll be able to answer your questions directly. But I wanted to just get back into the swing of things and do this video just to make sure there aren't any good comments or questions that are left unanswered. So let's see, what other questions do we have here? Here's a question. I have a question about traumatic brain injury settlements. I was struck by an 18-wheeler. I have multiple injuries, including TBI and PTSD. I'm currently being treated by a brain injury clinic. I have been told that at 62, my brain is functioning at the level of an average 81-year-old. I'm going through cognitive therapy, speech therapy, vision therapy, and 8 more therapies. I want to know, if I declare myself incompetent and name my son guardian ad litem, will I likely receive a higher settlement? You know, will that lead to a higher settlement? So that's an interesting question. I mean, usually in New York, the way it works is if you are incapable of making legal decisions for yourself, then, you know, your lawyer will apply to have someone like your son become guardian ad litem for you. So that particular procedure isn't something you can choose, right? It's not a strategy like, oh, I'm going to get guardian ad litem to get more money. It's more like if you can't make the legal decision for yourself, if you can't make certain decisions, it's something your doctor really has to decide and sign an affidavit, and then your son could become, or your wife, son, whoever is competent, could become your legal guardian ad litem for the lawsuit. So I don't think that, that process itself is necessarily going to lead to a higher settlement, because the overall amount that you're going to receive is just dependent on the injuries and the effect that it's had on your life. So the guardianship itself, I don't think will increase your settlement, but what will increase your settlement is being able to show that it's a life-changing forever injury and the overall damages in the case. But it sounds like, for the most part, if you need a guardian ad litem, it sounds like you have pretty serious damages, right? Because a person who's in a little fender bender and has a little boo-boo is not going to need a guardian ad litem. So, let's see, what other questions do we have here?